Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in this evening, as you can see, it's slightly gloomy in here because it is dark outside, session, I'm going to be talking about a situation where an employee sends themselves perhaps emails to a home email address, personal email address, containing some kind of evidence that that employee says is potentially relevant to something that's going on in relation to their employment. So it may be for evidential purposes in a grievance, it may be where they're going to say that they're a whistleblower and that they've raised certain concerns with their employer, or it may be evidence, they say, of some form of discrimination against them, or even just evidence to challenge the way in which something's been handled, like their sickness absence or their performance, or maybe some kind of restructuring and redundancy. So essentially what the employee is doing is keeping information that that person says they think is going to be relevant to them for some later discussion or process. Now, of course, quite often when the employee does that and they send that data or information outside of the employer's systems to their own device, for example, a number of issues can arise. So firstly, what the employee does may be a breach of data protection. I'm thinking particularly if there's information in there relating to other people, so other employees, service users, clients, customers, colleagues, all of those sorts of things. We're into GDPR territory, and the employee could get themselves into significant levels of trouble there. The second potential issue is around the sort of employer's own rules. Quite often the employee doing that will be breaching confidentiality provisions, maybe from their contract, maybe contained in some other form of restriction document, maybe a deed of restriction or deed of confidentiality that they've signed at some point. And I have seen lots of employers take disciplinary action, therefore, against the employee for having done that. And the employee may have no idea that in doing that, they're opening themselves up to that kind of disciplinary action. Recently, there's been a High Court case where Nissan obtained an injunction. So that's a court order to force the employee to give back the 100 or so documents that the employee had taken. The attitude of the court in that case, when the employee says, but I'm only keeping this because I'm thinking of bringing a legal action, for example, or a complaint internally against this organisation. This is all important evidence that I need. The court's attitude is that in any court action, there is a time and a place for what we call disclosure, which will be the part of that case where the parties are ordered by the court or the tribunal to disclose to each other anything that's helpful to their case and anything that's harmful to that case. So there is a kind of legal process there for the exchange of lists of documents and then the actual documents themselves. And the court's attitude was that is the correct time and place for disclosure of such evidence to be happening. It is not in the employee's gift for themselves to jump the gun and take that data from the organisation earlier on. So employees thinking of doing this, you're doing it absolutely at your peril. Employers, various angles for you to then tackle that scenario if it should happen. Please don't hesitate to get in touch if you've got any queries. My email is adenton@refreshinglawltd.co.uk. Thank you very much.